And there we go. Welcome, everybody. Thanks for joining HCDC's The Huddle. We've got a couple of great speakers today. Larry Kavanagh, he's the CEO of NaviStone, and Doug Gastright, he's an IP attorney with Ulmer Berne here in Cincinnati. They are going to be talking about and providing insights as to how you could be thinking about your business strategy. Larry comes at it from the perspective of a multi-time founder that's leading a VC-backed digital marketing focused company right now, or marketing focused company right now. But he is a former HCDC tenant and has exited a couple of companies. And then Doug will be coming at it from the angle of IP strategy. It's never too early for you to be thinking about what your IP strategy is as a growing business owner. And so he'll provide some insights as to how you should be thinking about it. As I said, go ahead and put questions through the Q&A. I'll be playing facilitator, and the session's recorded as well. So if afterwards, you want to go back and rewatch it, we'll have it posted on our Mighty Network. And you can also ask, if you'd like, if there's others that you want to share it with, feel free to ask us, and we can provide a link to others in your network that might be interested in learning more about HCDC, but also getting access to great content, from Larry and Doug. So we're going to go ahead and start with Larry. The format will be about 40 minutes for Larry, and then he'll take some questions along the way, and then we'll shift over to Doug for the back half of the session. Sound good?
Sounds good to me.
Alrighty. So Larry, I'll let you provide a little bit more detail on your background if you'd like. But thanks a bunch for joining us today.
Oh, no, thank you. And I'm going to share my screen. So let's see if I can get this working. All right. Paul, can you see the screen here?
Yep.
All right. So Paul asked me to talk about strategy today, and as he mentioned, I have a I like to say I'm a serial, or I think I am a serial entrepreneur. Other people have told me it just means I'm unemployable. But as Paul noted, I've been an entrepreneur for 23 years. Prior to that, I did at least for a while work for other people. I had 4 years in the publishing industry, and then for 7 years actually ran this was in the from like 91 to 98, ran a mail order catalog business. But for the last 23 years, I've been an entrepreneur. I had two sort of solopreneur consulting businesses. That's when I first became went out on my own. That's what I did, and then had a little bit of about 7 or 8 years ago, where I did it for a couple of years in between. But as Paul pointed out, I have founded 4 companies. The first was an e-com platform business called DM Insight. That was the one that was we really started in HCBC, and Pat Longo had about the same hair then as he had today, but was young and new to the place. I was younger and newer to the place and had more hair too. I think we were in the incubator for 5 years, and actually we were number 475 on the Inc. 500 list, I think, our last year in the incubator. I exited that business in 2011. That business is still going on. It changed its name. It's now called Calio. Did the solopreneur thing again for a couple of years, but founded another business called Melassa Group, which was actually acquired fairly quickly. That was a marketing technology business, a little bit like what I'm doing today. Then founded a marketing consulting business called Cohere One, that really worked with sort of direct-to-consumer businesses, and helping them with both digital strategy as well as direct mail strategy. And that business was acquired. And NaviStone is now the 4th business that I've been fortunate enough, of course, for-profit business I've been fortunate enough to be a part of. I also, just because 4 is not enough, I actually helped found a nonprofit school called Covington Classical Academy. And please, if at any time you have questions, type it, do as Paul said and type them into the chat box. But I'd love to make this more, as much of a conversation as we can. I think that's the way we can all get more out of it. So Paul asked me to talk about strategy, and strategy can mean like a lot of different things to different people and in different contexts. And if we were doing this live in person, I would probably popcorn around the room and say, tell me what you think strategy is. It's a little harder to do in this format, but this slide kind of gives a sense of like all the different kinds of things that people might think about when they think about strategy. And if you just use that word, I mean, are you talking about HR strategy, exit strategy, financing strategy? Is it your cloud strategy? Is it your work from home strategy? So strategy is a pretty broad word. And so what I did for this purpose, and I think it's really what is the most useful way of thinking about it as an entrepreneur, is really boil it down to more of like what the textbook definition of strategy is. And that's really around, what's your product, what's your value proposition, how does the product work, who is it for, how do how much people pay for it. And there's a number of different strategic frameworks out there, SWOT analysis, strengths, weaknesses, opportunities, and threats. Michael Porter, famous Harvard professor, has its 5 forces. There's another one called the 7 strata of strategy. And so, I think that that's sort of the best framework to think about. Now, before you all, like snooze, I'm not going to talk about the textbook definition of strategy or how that applies. What Paul had asked for is really, I think he said to me something like, Larry, you started a lot of companies. I'm sure you failed an awful lot in everything that you've done, particularly around strategy. Can you tell us what you learned from all that? And so, this is not going to be around the textbook definition of strategy, but I will pick, the examples, because he's absolutely right. I have failed an awful lot. One of the reasons why I like this little drawing is I think the only way I've learned a lot more from the times where things haven't worked than from the times that they have. And it's really those learnings that have allowed me to sort of continue and do sort of business after business. And the good news is, at least for me, by the time I got to number 4, I think I was really able to apply a lot of the lessons that I had learned from from all of the previous companies. So I'm going to break the lessons down into 4 different particular things that struck me as I was sort of thinking back about what have I learned about strategy in terms of product and go to market and pricing and that kind of stuff. And so the 4 we're going to talk about today are make it easy, trends, cash is king, and notice the leaks. So start with make it easy. So if you remember, I started my career, going back here, started as, the solopreneur, from 1998 to 2002. And what the way, what I sold at that time was really a consulting product with tools. I would, go into companies, typically companies that had marketing databases, and try to help them find ways that they could use that marketing database more effectively or help them solve a particular problem that they had. And so one of my very first clients when I was a solopreneur was a telecom business. And they, this was, back in, 98, 99, 2000. So very early days of telecom, very early, or not early days of telecom, but very early days of sort of the web, internet, and where telecoms were getting a lot of their business was changing as businesses consumed a lot more telecom services, primarily because of the internet. And so they provided me with a database of like all of their business clients, what their historic spending had been over like 5 years. And they asked me to sort of figure out, if I create a model that would figure out which of these businesses was going to do, super well in the future, so that they could make sure they applied resources, sales resources, marketing resources to those clients. And I went through all of the data, and I saw a couple of patterns, but the thing that was most predictive, when I looked back at sort of like the increase in spending of these businesses, between 1995 and 1999, 2000, was actually the length of their URL. So the shorter the URL, the more money a company spent with this, a client of the telecom company spent with them. And so that was, it was really sort of like, using personal ingenuity was the way that I was able to succeed as a solopreneur. So I thought, hey, this works. So I started this e-com platform business called DM Insight, and thought, hey, I'm going to use that same strategy where I'm going to go in there and kind of like figure out something that, all the other people trying to sell them e-com platforms wouldn't have figured out. And that did help the company grow pretty quickly. However, there's a real problem with the strategy. And perhaps it's obvious to many of you as you think about it. At some point, the company can, one person selling can only grow the company to so far, and you have to hire other salespeople who can sell the company's product. Well, since the way I was selling was based on like some weird, strange insight that I would get from looking at data, really tough to find someone who could sell that way. And so one of the lessons that I took from this, and I had to fix it at my ecom platform business, but is, don't design the product in a way that, only one person can sell it. And really I took that to the extreme in NaviStone and designed the product in a way that was still super valuable. But, I really thought ahead about how do we actually make it so, 100 people can sell this, 1,000 people can sell it, not just me. And NaviStone is actually really taking off today in large part because we're able to take our product into a channel marketing strategy where there are literally, we're training, sales forces that have 30, 40, 50 people for an individual channel partner today. But it's only because I learned the lesson of design it so that it's easy to sell. And again, if you have questions or you want me to talk more about one of these, by all means, let me know. All right, so second sort of, strategy product thing I learned was really about trends. And, you might have noticed that I have not adopted in my personal attire some of the trends that you see here, but these are, a 2020 male fashion show that is, this is what the current trend is, very different than what I'm wearing. How this so, yeah.
So sorry to interrupt you. I have one question as it relates to NaviStone. So your current focus with making it easy, obviously there's an evolution and you have insights from when you were designing it from your previous companies, but were there iterations at NaviStone that you had to kind of figure out to ultimately make it as easy as possible so that, like, say a channel strategy would work, right? So when you started NaviStone, would your initial product have worked in that kind of in its current state, or were there multiple iterations that had to happen that you had to kind of like have an epiphany, hit a roadblock to then be able to make it easy, so to speak, in the newest form? Does that make sense? That question?
No, that's a great question. And so I would say from the start of NaviStone, we actually had kept the product pretty easy throughout. I mean, granted, it's something that you always have to work on, like trying to sort of keep complexity out. What we needed to do for the first, really 2 years in NaviStone, I've actually got a slide a little bit later that talks about this, but I don't think I'll give it away by too much by talking here, is really how do we generate a strong enough value proposition? Because the product we had some field testing on when we started it. We had maybe 20 companies that had tried a very different version of what it is we do today. We wound up having it wasn't that what we did originally didn't work. It did. It just wasn't valuable enough, and we couldn't grow the business fast enough. And so we had to, the first really 2 years was about pivoting a couple of times, not around making it easy, but about how do we make the product more valuable and how do we figure out who it's most valuable to. But throughout it was, the make it easy part, because I had gotten burned so hard or learned my lesson so hard in the original DM Insight days, sort of like each of those pivots was still always thinking about how do you keep it, how do you continue to make it easy throughout. And it just resisted adding any kind of complex idea I have, we productize. We don't make it something that's that sales really has to deal with. Does that answer what you're asking for there?
Yeah, definitely. Thanks.
Sure. All right. So I'm glad you didn't ask me about what I think of the particular colors here or anything like that, because I could not. I don't really have an opinion. But my point on trends is so DM Insight, back in 2002, an e-commerce platform business. One of the trends that I had, one of the trends DM Insight was able to take advantage of, going way back to 2002, the types of e-commerce platforms that were available back then were these big enterprise platforms that cost $2 or $3 million to implement. They were really designed for the larger companies that were beginning to get into e-commerce. The trend that I noticed and a couple other people did is that the consumers who were most likely to use e-commerce back in the very early days, back in 2002, e-commerce was like 1% of retail sales. The consumers that were most likely to adopt it were people who were already accustomed to buying at a distance. They didn't have to go into a store and touch and feel things. They were, essentially mail order catalog buyers. People who bought from mail order catalogs were the people who first adopted, were the earliest adopters of e-commerce. Interestingly, you might think that's the most backward audience in some ways, but they were the most progressive because they didn't need to go into a store to feel and touch something. So the sort of innovation around DM Insight was, these mail order catalog companies couldn't afford to spend $2 to $3 million to implement an e-com platform. So although we didn't know it was a SaaS model or didn't call it a SaaS model at the time, DM Insight was was one of the very early SaaS models. We charged customers $5,000 a month that kept their site up, but also allowed us to sort of continually add features to their website. And it was a price point that traditional mail order catalog companies that were $10 million, $20 million, $30 million in revenue could afford. They couldn't afford the $2 to $3 million one. Now, I mentioned that I made selling really complicated and had to work on backing out and making that as complicated. I was very involved in the ongoing delivery of products, to the point that in 2005, 2006, that's where all my focus was. I had sort of lost that big picture look that allowed me to sort of see the opportunity that DM Insight had at the time. And as this moving things into present tense, when I said $5,000 a month for an e-com platform, probably many of you said well, that sounds like a ton of money. Now in 2002, it was cheap, but by 2005, 2006, you're dead on. Competitors like Magento had come along that were pricing things at more like $100 a month, that had figured out how to make that work. And today, Shopify, at $19 or $25 a month. But I was, the lesson was I was so immersed in the business that I didn't take any time to work on the business. I didn't sort of take a step back and sort of look at the trends that were going on, frankly, until that trend had passed by. So again, that's a lesson that I took into other businesses, and with NaviStone, I think one of the reasons we've been able to sort of continually pivot in a way that generally is moving us forward is I've organized this business such that I can take a step, I can do things, I take a step back and see where the trends are. So third one, this one starts to get a little bit, I tend to think of strategy, I tend to think of sort of business discipline in 4 dimensions. So we've got what we're talking about today, strategy, we've got product market fit, we've got execution, you've got people, and you've got financial strategy, financing strategy. And this one, it's a little bit into financing strategy, but I think it is actually really like a pricing example. So, again, going back to DM Insight, that business was growing super fast, like 80% a year. Like I say, it made the number 475 on the Inc. 500 list of fastest growing businesses. It was also profitable. We didn't take outside money. It had, really solid profit margins. But, we had gotten a line of credit, a $500,000 line of credit, and, within about 6 to 8 months had maxed that out. We had an experience where my controller came to me and said, hey, I made a mistake. I paid payables a little bit too far ahead, and we're not going to be able to make payroll. And I had actually had to literally use my credit card to make payroll. And, it was, when I took a step back and sort of figured out, okay, why is this happening? Well, I was, clients were paying us monthly, as I mentioned. So at the end of, this is September. So at the end of September, I would bill clients for the services I had provided in the month of September. Well, the problem with that is I kept on having to hire people. I had to pay my folks. Most of my expenses, or a lot of my expenses, were payroll. I had to pay them as the work was done, not after the work was done. And even worse, all of our hosting bills were paid. I had to essentially in September, I was paying for October service. So my revenue was out of step with where my expenses were. And so, I finally figured out, oh, shoot, I just need to bill, in September, I need to be billing people for October. I can't be billing that, I've got to be billing in advance as opposed to billing in arrears. And that little bit of like how you bill served me super well in Cohere One, because that was a company that was not super profitable and needed the billing in advance to keep cash flow positive. And it's really what's driving some changes we're making around NaviStone with adding some subscription component to our pricing. It just made it, that lesson of running out of money, or not running out of money, but growing fast, being profitable, and not having a lot of money really was something I learned from that experience. And then last one I have is
Larry.
Yeah.
Quick question for you. So I think that's such a critical insight as with cash is king. You can kind of you hear about it in business school. For those that have gone to business school, right? You hear about it in a lot of different settings from the importance or value of a business. It feels like there's lots of things Inc. 5000 lists, et cetera, that can focus people on revenue and ARR. And so, I guess my question is
there should be a cash 5000 list.
Right. Yeah. So when you have been out raising money, I guess, you hear about ARR from VCs, but do they get down, and really kind of analyze to the nth detail, those kind of elements of your business cycle?
So go ahead, please.
No, go ahead. Yeah, that was basically it.
Yeah. So my experience is that, they particularly as you're raising money, as you get into later rounds, absolutely, they go through your business. It's due diligence is more like a 45-day, including on-site visits. They're going through every aspect of your business, and they're focused more on the strategy side than they are necessarily on execution of people, or even, and to a certain extent, even cash. So that's where their focus is. And again, if you think about why they are investing, when you take an investment from really an angel fund or a venture capital fund, they want an exit. They're not investing. It's a very different thing if you want to build a business that's going to be sort of like a cash generating business. There are other sources of financing for that. That's not angel capital, VC capital. So the lens that they're looking through is how will this business be valued, which is really not around, even this whole thing about cash that I'm talking about. It is around, whatever the value metrics, continue to morph and change as to what it is they value. AR is certainly one of the things, churn is another, business model is another, rule of 40 is another. There's lots of different valuation methodologies, but short version is this is not the thing that they are. I mean, they might notice it and think, okay, that's good, but that's not the thing. That you're doing this more for, honestly, the reason why you do things like how do we bill in advance is around essentially self-generating cash as opposed to and needing less cash to grow than, it's essentially your customer financing as opposed to using outside capital finance.
Got it.
All right, so last one I had, and this is a NaviStone story, is notice the leaks. And so, DM Insight grew super fast, 80%, 80% a year for a couple of years. NaviStone, as Paul mentioned, is a venture finance business. And if I thought things were fast at DM Insight, they were even faster in a venture finance business. And so, we spent, as I mentioned, like the first couple of years sort of tweaking the product, trying to figure out, how, what would work in terms of selling it, what would work. And so we had made a few tweaks, and we were selling like crazy. We were selling to mid-market enterprise customers. We're landing, 5 to 7 new customers a month. We were landing names that, company names that I was super excited about, Quicken Loans, Wayfair, other companies like Zulily, Oriental Trading, and at least on the selling side, getting them in the door was going super well. The way folks buy, would essentially buy NaviStone's product is they would do a test. They would say, hey, we're going to use your product for 3 months. We're going to see what the results are, and then we'll decide if we want to continue or not. And so, as we were like zooming up a number of customers, revenue was zooming up. Honestly, we didn't pay enough attention to what's the continuation rate. And we noticed, hey, we're only getting about 40% of these people who try the product to continue. And we looked at it like, but we know this product works. I mean, Quicken Loans, they continue. They're like going on and on. Wayfair, they continue. They're going on, they're doing well. Why is it that this is working really well for some and not for others? Well, what we discovered, and Oriental Trading and Zulily are good examples. What we discovered is that our product worked really well for businesses that sold themselves products to consumers that someone would have to think about a little bit before they bought. So it's something we call the considered purchase. We had previously thought, hey, our target market is, you just gotta, you just have to have a business that's X size, maybe you're in retail and that's enough, and that was enough, or maybe you're in financial services. But what we learned is that what really mattered even more than those two is, was the business we were selling something that consumers had to think about, or was it something that was more of an impulse buy? So the Oriental Tradings and Zulilys of the world were impulse buys, and our product really didn't work for them. Even though we had spent, and unfortunately, we noticed this after we had sold 23 companies, that we had to have 23 failures where we had sold to companies that were sort of non-considered purchases before we realized, oh shoot. So anyway, essentially our conversion rate nearly doubled from about 40% to 80% once we started only selling the folks. And my lesson, and this was NaviStone, so I'll have to take this on to another company, is really pay a lot of attention, even in the early days, to like how people are continuing, like where are the leaks? Because there's we didn't have to wait we didn't need really 23 companies to learn that. We probably could have learned it after about 10 or 12. So that's Paul, that's the presentation I have. The one other thing I was going to mention is that while I told stories here and I did say, there's if you really want to learn strategy, it'd be worthwhile learning sort of more the textbook style of it. For anyone who is on this or viewing this Zoom, a group that I'm involved with, Entrepreneurs Organization and Centrifuge, are co-sponsoring a strategy workshop at Union Hall on November 1st. It's going to be hosted by a guy flying in from California. He's the host of the Scaling Up podcast named Bill Gallagher. We're going to have about 30 or so entrepreneurs who are there, some of them with their management teams, trying to get that textbook version that they'll then apply into, and it's really, when I say textbook, it's a workshop. You're actually going to be like trying to apply it on the spot to your business. Anyway, we have a few slots left. If you're interested, email me, I'll be glad to tell you more about it. So,
hey, Larry,
yeah.
Scott Jacobs. It's Scott Jacobs. How are you doing? I would be very interested in that. I've got the book, and we were looking at potentially partnering with them at one point on doing that seminar here. So I'm glad somebody else has picked up the ball and run with it. But
yeah, no, I noticed you on the call and was planning on reaching out afterwards to you on it. So excellent, happy to.
Yeah.
Hey, Larry, this is Apps. I think Greg Wilson may have introduced us a few years ago. So
he did.
Good to see you again. Fantastic presentation. A question back on your leaking slide. It sounds like, and I may be misinterpreting this, but it sounds like that is kind of you narrowed in on your ideal customer profile.
Exactly. We narrowed our target market. Okay. And go ahead.
Just to clarify, my question is the it took you losing some customers because they didn't get your full value proposition, right?
Yeah, 23 to be precise, but yeah.
Yeah. A few. That's more than a few, maybe. And you said you could have probably done it in 10 or so. How did you go about identifying that was the characteristic, right? That was the deciding factor. What was the process that you and your team went through to kind of, say, okay, we're losing these customers. What is it? Why is this one different than this one? What was that process like?
Well, I mean, in essence, like actually what you said was the thing we needed to do sooner. We actually got the team together and said, all right, we're losing these. Why are we losing these? And we threw out some hypotheses, but it was very much a team effort, to your point. It wasn't, we had some analysts come in and look at it. We actually sort of laid them out. Okay, what industries are they in? Was there some way that we sold them that was, we sold this one different than this one? And it was really just sort of as we laid that out that we eventually just got to, all right, what is is there something common among the types of products that we sell? And the truth is, once you put like all 23 up on one side and the 20 that we had done super well up on another side, up on like a whiteboard, and you go, oh shoot, yeah, it's really clear to me now what the similarities and differences are. But when you looked at them sort of like one by one, that pattern wasn't clear. It was really kind of grouping them all together and saying, what does this group have in common, and what does this group that we do really well with have in common? We listed those things, and once we saw it, it was like, oh gosh, that makes perfect sense.
And so, just if I could just quickly follow up on that, I mean, the factors that you consider, because there's a million factors you could have looked at, right? Org structure, business model,
right?
Target market. I mean, you could look at who is the buyer. I mean, you can
their gross margin. Yeah.
So how did you narrow that list? Because this is really interesting and I think important. I mean, for us.
And to your point, like what's the strength of our internal champion? Which was actually one of the first things that we looked at. And we're like, you know what? In these ones we lost, we had like some really strong internal champions, and some ones we're doing really well at. Like we barely know their names, and so it was sort of like it was more like putting them up in grouping and then saying, okay, is it this? All right, no, that one doesn't fit. Is it this? Okay, that one doesn't fit. And it was really sort of that process of elimination. But the first step was, and this is why I say, pay attention to the leaks, is we kind of like, we absolutely didn't pay attention because we focused on the ones that were working really, really well. And it was like, hey, had another big win, Quicken Loans just decided to double what they're spending with it. So, woo, we're doing great. And we didn't pay attention to, oh, we lost another one over there. What, and again, not that you shouldn't celebrate the good stuff, you totally should. But we got too wrapped up in the good stuff, and we didn't pay enough attention to the leaks.
One more question to my final question. Sorry. Did you have were you tempted at all to re-engineer your business your business model or your product, or were you tempted to try to change your business or your product in order to stop those leaks, to keep those customers that you were losing? Or did you realize there's big enough market over here with exactly what we're doing, we just need to go find more of these?
Yeah, no, you're exactly right. I mean, if the ratio had been 23 leaks and 3 we absolutely would have re-engineered the product. But to your point, it was more like, no, there's still plenty. In fact, there's plenty big enough market focusing on the businesses that need, that are selling products that are considered purchases, and made more sense for us to just change our focus, or really not even change our focus, like add a criteria to our target market, still way big enough that we have been able to build a nice size business.
Awesome, thank you.
Any other questions for Larry? So, Larry, can you flash up that slide again about the special offer?
Yeah, there you go. So
you see down there, make sure you contact Larry as soon as possible at L Kavanagh at NaviStone, and that's LKAVANAGH at navistone.com. If you want to, my guess is that these are going to go fast, so you probably want to reach out to him ASAP. Then I've just got one last question before we turn it over to Doug. But did you have to? One of the things that at a couple of the companies I used to work at, Larry, we used to do a lot. And granted, this is not companies that were scaling up. There were companies that were pretty established, right? But we did a lot of gain versus churn analysis. Is that, and it was one of those things that was completely embedded into the process of the company, right? You had continuous questions being asked, because if you ever lost a retail account or points of distribution, it was a pretty big deal, because it might be a big headwind then for your business. And so did you have to kind of inject processes like that into your business, whereby, hey, every month we're doing this analysis to make sure you kind of knew how to manage it ongoing within NaviStone?
Yeah, so we actually, we have a dashboard of 10 to 12 metrics that we actually look at weekly. And it's not the same metrics that changed over, I've actually got the very first dashboard we did in June of 2016. They've changed over time, but we added, of the people who we had signed in the last 3 quarters, what percentage of them had agreed to retest, or the inverse, what percentage had agreed, or were not, had dropped off. And that was something we actually looked at weekly, not monthly, as a way to put focus on a particular topic.
Got it. Good stuff. Well, hey, thanks, Larry. Much appreciated. Always good to hear about the different angles and insights that you bring. You and I have connected a fair amount in the past, and thanks for your time. So
you're welcome.
And thanks for the offer to everybody here. All right, so Doug, I want to turn it over to you. And so Doug is a morning mentoring participant with Dennis and team, and he is a attorney at Ulmer Berne, and knows a ton about intellectual property strategy. So we're going to turn it over to him. I am replacing the spotlight onto you, Doug. And so there you go.
All right, great. Thank you, Paul. And good to talk to everybody. And let me pull up a slideshow here. All right, are you guys seeing front the front slide of my slide deck?
We are, but we see your notes in the next, so I don't know if there's a different,
We're looking at
not
your
that that
speaker
necessarily
notes.
matters, but in the event you wanted to change your format.
One second.
No big deal if.
What about now?
Perfect.
Okay.
That's great.
All right. So we are going to be talking about a topic that may not always be fun, but I think we're going to try to make it fun and interesting. And that is IP strategy and execution. And so sort of what you'll see and what I'm going to try to get back to frequently throughout the discussion here is that IP strategy is first of all, it's not something you want to put off until a later date. And second off, it's something that you can do. It's within your means to do right now. And so there really is no reason to put it off. And so, you know, when we talk about execution of IP independently of strategy, you know, it's expensive to prepare and file a patent application. So that's probably not a surprise to anybody. And as a result, you sort of, you know, people I talk to, they tend to just put off all of IP because they know that once they start executing on particular pieces of an IP strategy, it's going to get very expensive. And so what I'm going to try to impart upon you is that instead of saying, well, a patent's expensive, so we're going to just put off all of our work on IP, my suggestion is to, as soon as possible, from the very beginning, if possible, to start, you know, developing an IP strategy, thinking about it and keeping it in mind, while recognizing that, you know, the ability to do so is within your means now, and it's not something expensive like preparing and filing a patent, which may come later. So quick introduction for me. Prior to becoming an attorney, I worked in software development at a number of local Cincinnati companies, Kroger, GE Aviation, and one other one, for almost 10 years in a software development career. For part of that 10 years, I was in evening law school at Salmon P. Chase on NKU's campus. And I have been a practicing attorney for 8 years now. So when I finished my law degree, I left a software career and came over to law. My practice is probably about 80% patent related, with the other 20% being tech transaction related. And so that could be anything from software services agreement, you know, subscription agreements, software license agreements, sort of anything where we're talking about technology and or professional services related to technology, and the way that we formalize those types of agreements. That's another big part of my practice. Some other things that I do, I'm one of the co-directors at UC's Patent and Trademark Clinic. This year, I had been a volunteer in previous years, and this year I'm one of the co-directors. And then I do a lot of mentoring and volunteering through local entrepreneurial communities like Ocean Accelerator, SoCap Accelerate, Centrifuse, and HCDC, as Paul mentioned. So when do we want to start your IP strategy? We want to start it now. And that's, I only say now because we don't have time machines and we can't go back and start it yesterday or the year before or anything like that. And the reason for that is that there's, you know, disclosure really can be the enemy of your potential IP and your future IP rights. And so disclosing things without understanding the effect of the disclosure and without taking certain steps before the disclosure can really harm you later. And so that's why I want to talk to companies often as soon as possible, even if we don't end up working together for a year or two, or we never end up working together, because it's so valuable for them to sort of understand as early as possible, as early in their life as possible, that sort of damage they can do without even realizing it or understanding it, the kind of damage they can do to their intellectual property. And so by taking care of your IP strategy early on, you develop a basic understanding of what your intellectual property is, the effective disclosure on your intellectual property, and the steps you can take to preserve your intellectual property, and then eventually, eventually have a patent granted or have some other enforceable intellectual property right granted to you. And so that basic understanding plus some business processes can basically preserve your potential IP until such a disclosure becomes necessary. And we'll go into more examples on this, but if you've got software, you've got a software designed, you've got the source code for it, you've got it working in a staging or a QA environment, having a process for an understanding and a process for why you would want to evaluate that source or that software that's living in your staging environment before you send it to production. Understanding what's there, understanding what steps you might want to take, doing all of those steps before you actually put it out into production, and having a business process for making sure all of that gets done can be really valuable. Your disclosures around potential IP, they should be something that's foreseen. It shouldn't be a surprise to you. You shouldn't be launching something on Monday and then realizing on Friday that you might want to file a patent on it. Your disclosures should be well-reasoned and intentional. So we don't want to accidentally disclose things. We don't want to share source code with consultants that are going to be working on it and have those consultants not be under a non-disclosure agreement, because that could come back and bite you later as a public disclosure that you didn't intend. And then you need to understand what IP rights might be damaged by those disclosures and what steps you need to take before disclosure in order to preserve them to the point where you might want to, file something on them or have something granted on them. So an analogy I use sometimes is to say that IP strategy, it's like an architectural diagram. And that could be an architectural diagram for a building or a house or a structure, or it could also be for software. That architecture diagram, it's critical for the long-term success of building the software platform or the building or whatever it is you're building. That initial planning step, it's critical for it. But when you get to the end and you look back, it only represents a very small percentage of the budget for the entire project. So, if we're talking about investing a very small amount of time and effort into developing this plan, so that when you actually go and start building these things, you know what you're doing. So the idea is to create the strategy now, as soon as possible. And then that strategy sort of it lays out the road, and you can sort of look forward and say, all right, now that we have the strategy, now we can see points along that path where we might want to implement or execute portions of that strategy at a later time. And so that sort of bites back to what I mentioned earlier, where you can develop the strategy now, and then you sort of all of the major costs of protecting your IP, filing patents, things like that, all of that can sort of be later on in the process, but there's still so much value in getting the strategy put together now. And then, not all of you guys are planning to be acquired, I'm sure, but I would imagine all of you would be open to that if the right opportunity came along, or that, investment opportunities also relate. But one of the real underlying values for especially small companies to preserve those IP rights is that you can come up with the strategy, you identify all your IP, and you put processes in place to preserve those IP rights. And then if the timing works out, potentially, you are acquired, and then whoever acquires you is the one that has to actually pay to execute on that IP strategy. And so you sort of, you develop the strategy, you can show that during due diligence, it has value. You can associate value with the execution of that strategy, but then somebody else has to pay all the fees and take the time to execute on it. So that's really, for some companies, that's a best case scenario. All right, so this is the first of a couple diagrams we're going to look at. And this one can be summarized basically as keep your stuff secret until you're sure that it's protected, or that whatever IP rights there that you might want to preserve are preserved. And so there's that blue dotted line over to the right of the slide, and sort of to the left of that, it's marked secret. To the right of that, it's marked publicly disclosed. So everything to the left is still secret, which we'll talk a little bit about what secret means. And everything to the right is something that's out in the public. And that boundary line right there that we're talking about in between being secret and publicly disclosed, crossing that line is what's either, in some cases, it can destroy certain IP rights if you've not already started the process to secure them. And even in the best cases, it starts to degrade your IP rights when you cross over into that public disclosure without, taking the preceding steps to start protection. And so now focusing on the left of that, let's see, does this work? Okay, yeah, so that didn't come up exactly where, all right, I'm not gonna try to use the pen again, but focusing on the left side where there are the boxes, that trade secret box is what we're gonna start talking about. And trade secrets they're kind of an interesting intellectual property right, and they're not one of the popular or really widely known ones like copyright or patent. But a trade secret is essentially anything that you have, any information you have that has value that is not publicly known. So it has value and it's secret basically, and that you have taken some reasonable steps to protect. And so if we're talking about your list of all of your customers and your customer contact information and your historic sales with those customers and your potential future plans for developing those customers, that list of information is a trade secret because it has value. You've kept it a secret. You don't post it on your website. You don't post it on Facebook. It's not out in the public, that list. Some of the information on that list is out there and available, but that list in the form that you've put it together is secret. And then you've protected it. So you probably store it on a database or in a CRM or something like that. And only certain of your employees have password access to it. And so you take reasonable steps to protect it. Trade secrets are an interesting one because they have their full weight and value and without registering them. So they're not a registered intellectual property, right? And the benefit that a trade secret gives you is that if you maintain all of your sort of internal information and data, if you maintain it all as a trade secret, you can enforce your intellectual property rights in that trade secret to try to prevent or punish or claw back your trade secret information that gets outside of your ecosystem through misappropriation. And so, a common scenario is with employees or consultants, but it could also be, a bad actor or a hacker or something like that. If they get a hold of your trade secrets and they take them out and start using them for themselves or, for the benefit of other people, selling them, copying them, spreading them out, that trade secret right, to the extent that you can go to a court and say, look, we maintain this as a trade secret. We kept it secret. We had reasonable protection on it. This person misappropriated it, and now they're using it in violation of our trade secret right. It can give you a very powerful remedy in that the court can essentially force that person to stop using it. You can get damages for their use. The court can force them to the extent they've made it available online, the court can force them through an injunction to take those materials off of the internet. And so a trade secret is a good one to know about. And it's not a super critical IP right, but it's important to know about, and it can sort of be a central column of your IP strategy because in theory, everything that is within your business should start out as a trade secret. And so, if you've got something that eventually becomes patentable invention, at some point it started out just as emails and descriptions and documents and plans, which at that point were just trade secret information that you eventually use to build up to sort of the critical mass where you say, all right, let's go file a patent on this. And so that's what this diagram sort of indicates. Everything starts out as a trade secret. you have business processes in place to identify your trade secrets, or at least identify the ones that need to have a higher level of protection than everything else. Because, for example, your business email is a trade secret, but you might have a different level of protection on your business email as compared to your super valuable, critical analytic data set that's stored on a database somewhere. So sort of as a foundational component, you start to think of all of your data and information as trade secret, and you start to treat it that way. Staying on the left side where everything is still secret, then you start to think about, all right, we've got all of this information that we keep as trade secret. What do we want to do with it, or what do we need to do with it while it's still secret and before we move across that line to where it's publicly disclosed? And your options there are the other more common types of IP you probably heard about. Patents. You may want to file patents on some of your trade secret stuff. Some of your trade secret stuff is certainly copyrighted, and you might want to register some of those copyrights. And then some of your trade secret stuff might lead to trademark filings. And then, while it's not classically an IP right, I always mention agreements here also, because an agreement, like a transactional agreement, is between, typically it's between you and one other party, and it can create rights and obligations between you and that other party that are in some ways more powerful and more enforceable than your other IP rights. And so the nice thing about a patent is that you can enforce it against anybody in the world, or anybody in, let's say if you have a US patent, you can enforce it against anybody that's practicing your technology in the US. But the nice thing about an agreement is that if you can get that other person to accept the agreement, to sign it and be in that agreement with you, it's much easier and stronger to enforce those rights within the agreement against them as breach of contract or some other sort of agreement-based cause of action. And so think of agreements as being a way to sort of create IP rights that didn't previously exist, but only between you and the other party that's accepting that agreement. So patents we'll talk about a little bit. Things that you want to evaluate for patent filings are, it's focus more on the functional aspects of your technology or your innovations. And I assume a lot of you guys probably have software innovations. So we'll sort of talk about software, and then during the question section, if anybody isn't software and has other questions, we can cover those, but we'll focus on software a little bit. Your software, the things you want to identify within your software for potential patent protection while you're still in this trade secret stage are anything in your software that is new and non-obvious as sort of the initial threshold. So have we, if we've just taken a library, a software library, an API or something else that somebody provided, and we're just sort of using it identically to the way that they provide it or with very little added onto it, then it's probably not new or non-obvious enough to really seriously consider for patent protection. On the other hand, if in your particular area of business, to the extent that you've encountered a problem, so you're in this area of your business and then you found a small problem within that area that relates to the implementation of your technology, the solution that you came up with for that small problem could very well be something that's patentable, because the more specific your business is, the more likely it is that nobody else has ever encountered that particular problem, which means it's also likely that nobody else has ever invented that particular solution. And so, there are a number of things to look for within software as far as what you would want to patent, and that's just one that I describe to clients a lot because it's a helpful one to get them to start thinking. Other areas are, nowadays, anything related to security, data security, whether data is at rest or in transmission, those are all really good areas to look for features for patent protection. One notable thing about patents, we discussed with trade secrets that they're unregistered. You just sort of, by maintaining things as trade secret, you get that protection. With patents, they are a registered IP right, so you only get the benefits of patents once you file them while they're pending. You get some rights while they're pending, and then once they issue as a patent and become enforceable, like once the USPTO grants the patent, basically, that's when you actually get your right. Copyrights are another type of IP. Copyrights are sort of interesting because the basic requirement for a copyright is that it be created and put into some tangible form. So that could be, a poem that you've written on a piece of paper. It could be a song that you've recorded. It could be source code that you've typed out that's been stored in a memory on a computer. Once it's created, and once it sort of, as long as it sort of crosses this pretty low threshold for creativity, then a copyright, an unregistered copyright, just springs into being and immediately is owned by the author of that copyrighted work, absent some agreement with that author that causes it to flow on to the company that they're working for. And so, the minimum threshold for creativity would prevent you from copyrighting a word. A single word is not enough. A couple words is probably not enough. But once you get up to where you have, phrases, sentences, paragraphs, and it's, not something you're copying from someone else, or there's sort of a minimum level of creativity there, that's enough for a copyright. Copyrights registration is optional. So, like I said, as soon as it's fixed into some form, that right immediately is owned by the author and comes into effect. You can then take your copyrighted work and go register them. And if you're going to enforce your copyrighted, if you're going to enforce your copyrights against infringers, then you need to go register them sooner than later. But they can also remain unregistered for as long as you wish. And there's actually for software, especially where you've got source code that's constantly being updated to fix bugs or make improvements, sometimes it doesn't actually make sense to try to copyright your code every time you change it. And so there are some strategies as far as copywriting when it comes to the software world. Trademarks are the third sort of big area of intellectual property that you guys have all probably heard of and know a little bit about. The purpose of a trademark is actually to identify the source of a product or service or good to consumers. So it is supposed to be for the protection of consumers, but as a company that has brand value and has customer, trust built up in your products and services, a trademark can be valuable to that business because it lets the business it gives the business a right that they can enforce against their competitors who are competing in a way that confuses that business's customers. So if somebody picks a name that's very similar to your company name, or they start offering a software subscription service that has a name very similar, or a logo that's very similar to yours, and it, you can sort of look at it and objectively say, I think they're trying to leverage my brand value into launching their brand. That's when you can step in with a trademark and say, you've got to stop, you've got to change your name. A court can enforce that for you. Trademarks are another one where registration is sort of optional. There are state level trademark powers. So if you don't ever register your trademark with the patent office, the Patent and Trademark Office, you can still have some common law state rights that you can enforce in a particular state, but the trademark registration makes that right national in some way. So if you're in Ohio and you're operating your business and somebody else starts competing with you in Ohio, you can use that unregistered right. But if they're in California, you probably cannot use that unregistered right. And so all of these sort of IP buckets that we just talked about coming out from trade secret, the patent, copyright, trademark, those are all things that you can start the process of protecting those things while all of your information still remains secret and it's all a trade secret. And so all of that can occur on the left side of this line where everything's still a secret. Now, when we move to the right side, like I mentioned, some of these rights start to get damaged or even destroyed. So reasons that we might move something out of the secret area over to the right are for marketing purposes. So if you've got marketing materials, they might be a trade secret while you're working on them, first coming up with them, reviewing them, et cetera. But once you publish them, you sort of put them out there in the understanding that, we created these for the purpose of marketing. Maybe we want to evaluate them for copyright protection or a trademark filing before we put them out there. But ultimately, we know that we're going to use our marketing materials to put them out there and have them be our marketing materials. Other types of disclosures are selling your stuff. So if you've got a software service that you've got on that QA or staging environment, once you move it over to production and people can use it publicly and you're selling subscriptions to it, that's a public disclosure. And so that's something that you want to evaluate before you move it over there. Do we want to file a patent on this? Do we need to file any copyrights? Do we need to file any trademarks related to our software name? Anything like that. Using is another disclosure event. Using is a little different than selling. But for example, if you have, let's say you have some part of your software is like a black box process that takes input data and spits out really valuable output data, and your customers never actually interact directly with that black box. Let's just say it's something that, you sell a service to the clients, they give you their data, you manually use that black box. That is arguably, sorry, didn't move enough. That is arguably that use in public, even though your customers aren't interacting with it directly, that use is enough to arguably have that black box be out in the public. And so you will need to evaluate, do we need to file a patent on it before we do that? And then the last sort of public disclosure event I have here is granted IP. And so when we're talking about these registered IP rights, you can start the process of protecting those while they remain secret, but by the time they become publicly enforceable, in almost every case, if not every case, they're publicly available at that time. So if you file a patent, it can remain secret for a period of time, but once it actually becomes enforceable against the public, then it is publicly disclosed at that time. Now we're moving on to the next slide.
Hey, Doug, quick
Yes.
question. So where would things like demo days or things like, investor meetings, et cetera, maybe fit within some of these things? Are those, public disclosure events or, how might people think about those?
Sure. So like a demo day where especially where you're showing parts of your technology to the general public, that's a public disclosure, and there's not a whole lot you can do about it. Other than to rely on the argument that, yeah, we showed them our website or we showed them a video, but we didn't actually go down into the details and tell them exactly what enables our technology. So, for demo days, you keep it at a high level and you sort of recognize that there are some risks, but there's not a whole lot you can do about it. For investor meetings or, meetings with consultants, meetings with, just other people you meet with in business, and you want to sort of show them a peek behind the curtain as to what's going on in your software, your technology. That's the scenario where you want to try to have a non-disclosure agreement in place with them, because, that for purposes of trade secret, that non-disclosure agreement is sort of considered, yeah, you took reasonable steps to protect this information. For patent purposes, if you got that non-disclosure in place, then you shared them some details, but you put them under an obligation to not publish them, so they're not going to consider that a public revelation of your stuff. So yeah, non-disclosure agreements are good. A lot of investors just say no to non-disclosure agreements, or a lot of people that you might want to go to and talk to about your technology, they're just going to say no to non-disclosure agreements. And so the next best thing is to have your a patent filing basically before you go into that meeting, because then you say, I want you to sign this NDA. And if they say no, you say, okay, that's fine. I've got my patent filed. So, beware that if you start to copy my stuff, it may be enforceable in the future. All right, so this is something I'd not put together a Venn diagram like this previously, but I thought you guys might appreciate it. This is sort of those big four bundles we talked about already: trade secrets, copyright, patent, trademark. This is sort of a visualization of some of the things that you might find in each of those categories. So we've got this outer ring that everything is with inside of that we consider trade secrets. So pretty much everything we can treat as a trade secret initially. And then within that, we've got our circles for copyright, patent, and trademark. Over on the left, things that are going to have copyrights in them when they initially are authored, and that you might want to evaluate for registration of those copyrights. Images, photographs, video, all of your valuable content that you're creating as part of your business. And that first one there, images, photographs, and video, as well as also text content that you're paying people to produce, or that people that are using your platform are interacting with. That's the kind of stuff that might make sense for copyright registration, because those are the kind of materials that somebody is going to come to your website and read a document that you provide and say, hey, this is really good. I'm going to copy it and start using it in this class that I teach, or something like that. So your content is a really good source of stuff that you want to consider registering. But then also you've got your marketing materials, which, marketing materials may not always make sense to register a copyright on, and probably doesn't. Your data sets, your customer information, business information, analytic data sets, those are all sort of in theory copyrighted, but again, not one you necessarily want to register. Technical designs, plans, specifications, business plans, forms and templates. So like if you have a service component to your business and you have some really useful forms that you have produced that your customers use, during some sort of a session or scenario that they run through, or you run through with them, or if you're a consultant and, you see this in consulting services a lot, those forms and templates are good ones to copyright and register, because that's the kind of thing that somebody's going to say, hey, I really like that session that so-and-so did. I'm going to copy all their forms and go start doing this myself. Over on the right, when we're talking about patents, technical innovations, user interface, user experience innovations, process innovations. Generally, we're looking at functional features of your technology here. And this is both sort of in their implemented form, but also at a high level. And so what I mean by that is distinguish, your source code is a particular implementation of a software process you've designed. And so if we look at where patents and copyrights cross over, we actually see source code is listed in there. So your source code is just one implementation of the software process that you've created, though. You could implement that same software process in 10 different languages and have 10 different, complete libraries of source code. And so when we're talking just about patents, we're not actually talking about that source code. We're sort of talking about the abstracted software innovation that you invented that then led you to create that source code. So then where that area where we cross over and say, all right, now this is something that might have both patent value and copyright value. We're talking about source code. Again, we're talking about graphical user interfaces, the way it looks, the text that you're using there. Ornamental features is kind of an interesting one, because not common, but there is a type of patent called a design patent that lets you protect the ornamental features of things distinctly from their functional aspects. And so, a car, the design of a car might be protected by a design patent, but then some parts of the design might also be functional due to aerodynamics and things like that, that might be protected by your more functional patent. Down at the bottom, trademarks, things you might want to value for a trademark are the name of your company, the names of products, services, software, phrases that describe your software. Very rare, but brand aesthetics can also rise to the level of trademark protection. So if you started making a soda that had a red can and like a cursive script that was sort of like Coke, but it just had a totally different name, Coke would probably be able to step in and say, no, you're copying our brand aesthetics. You've got to stop. The area where copyright and trademarks cross over, logos, you might copyright your logo and register that, but you might also file a trademark on it. Creative phrases that describe your stuff. I sort of summarize this one as anything that is a creative source identifier. So it identifies you as the source of a product or service, but it also goes above that minimum level of creativity required for a copyright. The two other, the crossover between all three of them and the portion between patent and trademark, there's not a whole lot of crossover there. So I was brainstorming, trying to come up with something, but they're not rare that you would ever come up with something like that. But one area where they might all three cross over would be like the front portion of a car grill, because that's got functional aspects. It's got creative aspects in the design and the layout. And then to the extent that a single brand like, Mercedes used the same exact or very similar car grill on all of their cars, then they might also develop some trademark protection in that brand aesthetic. But that was just kind of a trivia one that I came up with. All right, so this is where we start to talk about how we put this all together now. So what I recommend for clients for putting their IP strategy together is basically you audit your current and future potential IP, and then that audit results in a document that you can use to review and track your potential IP. And then over time, you review that and you regularly update it. And, to the extent that anything comes up on that says, consider implementing this now, then you consider implementing it. Usually when I do that with clients, it usually takes about an hour to an hour and a half to come up with, to talk through all of their IP that we can come up with and for me to put together notes. And then it takes me another hour, hour and a half to put together that document and give to them. And then that's sort of their starting point that says, all right, this is what you're going to refer back to for guidance on what you need to be careful about and when you need to reach out to your IP counsel. Related to using this IP strategy, it is better to talk with your IP counsel once a month or once a quarter than it is to only talk to them every couple of years. Because if you're only talking to them every couple of years, you're sort of forgetting everything that you talked about the previous time, and they're not able to warn you of pitfalls or changing circumstances. And so it's much better to be proactive, even if it's just a 10-minute phone call a few times a year. It's much better to be proactive with your IP counsel than it is to be reactive, where you're sort of in this emergency scenario where you say, oh, we didn't realize we didn't do this. We started it 6 months ago. Now we've got to hurry up and file a patent on it, something along those lines. One of the benefits of that sort of regular touch point with your IP counsel is that you start to develop a little bit of an in-house issue spotting skill and knowledge base. And that sort of lets you, as you get better at tracking and identifying some of these IP issues, then you are more likely to spot them without having to reach out to your IP counsel, and you're more likely to know when is the appropriate time to reach out. And then the final thing is, you want to review, as you review that IP strategy document, you want to execute on specific tasks from it. So, one of the things that might be in there is under the patent section, we might identify a particular patent potential and say, we plan for this to release in August of 2022. So we're going to put a task in there that says we need to evaluate this for a patent filing by May of 2022. All right, and so this is one of now that we've talked a lot about IP strategy and what you might want to protect and why, this is sort of a pause point to pause and step back and really think about what you in particular want from your intellectual property. And so, with any IP strategy or any task we're doing related to our IP strategy, the goal is to get enforceable patent rights or IP rights for you. So if we file a patent, the ultimate goal is to get a patent issued so that it's an enforceable patent, et cetera. But, what I try to caution clients on is that there's a lot of value you can get from a patent filing, especially before it ever issues by the patent office. And so if 90% of what you want to get from the patent, you can start taking advantage of as soon as it's pending and as soon as you file it. And then the only 10% that you're missing is the ability to go sue people and litigate over the patent. You know, I ask clients a lot, I say, do you want to run your business and benefit from your IP, or do you want to become a full-time patent litigator? And usually they say they want to run their business. And so some of the things that I like to call out for them, sort of the pre-advantages we can take care of and make sure we're leveraging. There's a marketing advantage in that your customers prefer innovative products. And as soon as you file a patent, you know, you can be patent pending. There's a competitive advantage because if you can publicly project that you have an aggressive, strong, broad IP strategy that you're executing on, then your competitors are in a position where they want to copy you, but they're not exactly sure what's out there because, you know, as you're executing on your IP strategy, much of it is remaining secret and has not yet moved over into that public disclosure space. So it's kind of like they're walking up to a yard and they see a sign and it says, beware of dog, but they don't see the dog anywhere, but they can sort of, you know, they get a sense that the dog is there. They're just not sure where it is. And so for them, that creates discomfort and it can push your competitors towards pivoting around you or reaching out to you for licensing opportunities or partnership opportunities instead of just trying to outbuild you. And then there's a credibility benefit. Investors, somebody looking at an acquisition, partners, they're all going to ask you about your intellectual property and you need to be prepared to respond. You know, the IP strategy document is a really good way to respond, even if you've not executed on much or any of it. Because if somebody's looking at you in due diligence and they ask you if you filed a patent, the worst response you can say is, no, we haven't, and we don't even know why we haven't. We just didn't have the time or money to do it. A better response is to say, no, we haven't, because we evaluated the patent filing with an IP counsel and we decided it wasn't worth it. And an even better response is to say, either yes, we plan to file a patent, or we already have filed a patent. And so you want to be further along on that scale as far as building credibility during due diligence or other discussions. And so to summarize the above, basically, you know, when you talk to your IP counsel, they can guess, they can estimate, they can give you their gut feeling, but you and they cannot know or control whether or not your IP right that you're seeking will eventually be granted at the end of its journey. But what you can control is the leverage and value you get from that potential IP right while it's still pending, in the forms of, you know, marketing, competitive advantage, credibility, et cetera. So, you know, again, we're focusing on getting the patent. That's the ultimate goal, but use it along the way. And the hope is that even if we never get to where the patent is issued, we still want to get all the value we can out of it while it's still pending. All right. Any questions? And if you guys don't have questions, I put in some here that I can just run through.
Okay, we've got about 2-3 minutes left here. So anybody have any questions for Doug? And otherwise,
Doug,
as he said, right?
Hey, Doug, this is Apps. Do you typically work in conjunction with an existing attorney relationship, or you know, do we have to establish a new relationship with Ulmer, and if we've already have an attorney relationship?
Yeah, it is not uncommon to have multiple law firms or multiple attorneys, and especially since IP can be a little bit of a niche area, and especially when you get into something like software IP, a lot of firms just don't have that capability. And so it's not at all uncommon to say, you know, firm A is our firm for corporate issues and employment issues and fundraising issues, but firm B is our firm for IP issues, or, you know, even some subset of IP issues. So that's not at all uncommon.
Hey, and that's exactly what we did. Doug helped us with our patents, but we had somebody else handling other stuff.
This was not planned to have Larry and Doug on here in this scenario, but it ended up being serendipitous. So. Any other questions for Doug?
This is kind of tactical. If no one else has a question, I'll go ahead and ask it, but I'll pause to let someone else ask if they have one. Okay, hearing none. Doug, software development in India. If we're considering hiring a partner to help us develop some of our platform out of country in India specifically, any specific concerns there? Is the IP protection and laws and enforcement relatively the same?
They are relatively in sync. So there, with any agreement, there's part of the agreement that describes what countries or what states within the US, for example, the country or the state's laws that apply to that agreement and what it's being interpreted under. And so when your developer's sitting in Ohio, it's easy because you say, all right, this agreement is under the laws of Ohio. You can go to an Ohio court and enforce it, et cetera. For a developer that's sitting in India, what I would recommend would be to basically execute a set of agreements that say, we can enforce all of these under US rights, and in Ohio or wherever else, but we can also execute them all in India if we need to. And so basically you would be the concern would be that you could have a right that you can enforce against them in Ohio in the US, but if they're in India, it becomes a logistical issue with then enforcing that right, because they can just, to some extent, they can just ignore your legal process that is starting to occur in the US. So, I would make sure that your agreements have the ability to enforce them both in the US and in India in particular, if you need to.
Awesome. And you're going to give us your contact information. Yes, Doug?
Yes.
Thank you.
Yeah, and if
Carlton,
anybody wants a copy of the slide, also, I'm happy to share that with you if you found any part of it helpful.
all right, last question, Carlton.
My question is, so with us, we work with a bunch of different clients and help them support them in a myriad of different ways. But we have a new client that's on board who's actually going to be doing some cool things in terms of NFTs. In terms of IP, what are some of the things that are like in this Bitcoin digital space that have come up? Do they still apply to or follow the same rules in terms of IP and protection?
Yeah.
Or is it a little bit different?
So your patent rights are sort of the same in the token NFT space. If you're using either a pre-existing blockchain or a new one in a new and non-obvious way, then your patent rights are looking good. So patent rights, nothing in particular. Open source becomes a big issue, can become a big issue in this space because some of these blockchains and some of the automated contracts and things like that, they have either a requirement or at least an expectation that they're going to be open source to some extent. And so that's an area where you really need to track what open source stuff is going into your code and what sort of open source restrictions are coming with it, because all your open source stuff has a license that comes with it. In the best case scenarios, those licenses are not so bad, but in the worst case scenario, they can prevent you from patent protection, commercializing, et cetera. Another thing to think about in the token and NFT space is the potential, if you come up with like a symbol or a name or something like that for your token, that's a potential trademark.
Okay, thank you. Just appreciate it.
Yeah.
Thanks, everybody. So Doug, much appreciated. Really appreciate the insight. Love the charts, the Venn diagram. Thanks for creating that, because I think it was, pretty awesome to be able to see those things come together collectively.
Cool.
So for everybody on the line, next month, we're focused on customer discovery, and we've got a woman named Kelly Berry from the National Center for Economic Gardening, somebody that I worked with a fair amount in the Office of Innovation at HCDC. And she's gonna talk about why you should not ask your mom for feedback on your products. So she'll equip you with a bunch of different ways to manage secondary research and primary research to improve your overall product value proposition and meet your customers' needs more effectively. In the meantime, don't hesitate to reach out to Anthony, Trish, or myself, or Pat with anything you need, and we'll connect offline.